With that, I do have, and I'd like to ask for an amendment to the minutes. We'll do that first from February 3rd. That day, I was actually having technical difficulties, so Lynn Edmonds did not call the meeting to order. Vice Chair Haggerty took care of that. So if I could please ask for an amendment to the February 3rd meeting minutes to reflect that.
Chair Edmonds, I would move to amend the meeting minutes as so stated.
Okay. Is there a second? Second. All in favor, please say aye.
Aye.
Chair votes aye.
And Ms. Edmonds,
Sure.
I would then move to adopt the amended minutes.
Okay, great. Thank you. Is there a second to adopt?
Second.
Thank you. All in favor, please say aye.
Aye.
Aye. All right. And we will move right along to 4318. We've got technical revisions, and we'll do these together. 4318, student use of personal wireless communication devices, and 7340.
Okay. I'm going to pull these up on the screen so you can see them. Thanks to our tech services and to Matt Morrison specifically, who helped me learn how to use the screen beam in the room so that we can live edit on the screen when we need to, and look at these a little more easily from the table. So our first technical revision in policy 4318, when we adopted the policy, we did not include legal references. So the simple revision here is that staff added the legal references to this policy, mirroring what the School Board Association has. These statutes really have to do with the authority of the board, constitution of the board, their authority to do this kind of thing. And the last one is the actual statute, I believe 390.2 is the statute that deals with wireless devices or cell phones, the statute that was passed last year. For the next policy, also a technical revision, employee dress and appearance. This is also a legal reference provision, and you can see it right here in the bottom of the policy.
Great. So as we can see, they're just citations that were corrected or included. You know, nothing was done to the body of either policy. So can I get a motion to put, let me get my date straight before I make this. Let's see. So that would be, I think, the March 3rd meeting? No, we usually go, let's see, help me out, March 17th? Does that align with?
Still trying to find it.
I know. The motion will be, we'll put these on consent, and I believe for the March 17th meeting
That should be
is
right.
consistent with what we've been doing. Okay, so can I get that motion, please?
Chair Edmonds, I'll move that we put the policies cited on our consent agenda for the March 17th board meeting.
Okay. Thank you. All in favor, say aye.
Aye.
Aye. Any opposed? All right. Next, we have repeal and removal.
Yes, I discussed with Neil how we might best do this, and he advised that we could probably do this the way that we've been doing some other things and do this in a batch, okay? This is new. We haven't done this kind of item here at Policy Committee, but it is important. Currently, we have 238 items, I think, in our old policy manual. And in working with our HR staff, what we have found is there are a lot of policies in there, for example, in the personnel part, personnel numberings, which are 3s and 4s, I believe, that shouldn't be there. We had already taken some action on policies, and some policies were missing, some policies were there. And so what we found was that whenever we are moving a policy, we're migrating the policy, we use things like these kind of correlation tables and manuals that we get from the School Board Association. And we also have, for example, conversion tables that they provide for us. You can see this one's heavily used. And so while the correlation table may say this replaces a policy, that single policy might be coded in 3 places. And so what we have remaining are 2 other policies in the old manual that weren't pulled down at the same time the one policy was. So it might be a 2, 3, and 4, 2,000, 3,000, 4,000. But the 2,000 are removed, the 3,000 and 4,000 stayed there. So what we did is we went through and we identified, I think there are 13 to 15 items that in total will be, I think, 23 or 25 total removals from the old policy manual, totally based on 4 categories. I'm going to pull up the précis here so that you can see what those categories are. So category 1, these are repeal of duplicate policies. So when policies were initially adopted or migrated, we identified one, and that one was replaced and it was repealed. So when you pass a policy and it replaces another, we post one, remove one, or more, right? But there are many policies that were coded in 2 or 3 separate locations with 2 or 3 separate numbers that did not come down. So we have many duplicate policies that could be repealed. They weren't pulled down initially. Now, because they're still there, they need to be repealed. That requires action by the board. So we're going to request the repeal of those policies. Let me pull up that document so you can see what those policies are. This is the document that's included in the as backup. Let me make that a little bit bigger. There you go.
And Dr. Crane, let's just clarify for anybody that might be listening online or will see this later on the recording. This is not, when we say that we're going to repeal or remove a policy, it doesn't mean that the policy no longer exists.
Correct.
We are specifically talking about the old manual. And correct me if I'm wrong, I just wanted to cite this example. So for example, on the repeal of duplicate policies, 2304 faculty employee dress code is going to be proposed to be removed, but that we still have that policy, it's just now 7340 in the new manual.
Correct.
So I just think it's important for us to, ensure the public that this doesn't mean that these policies no longer exist.
Yes.
Thank you.
When I created this table, I wanted to be very transparent. There are links for the policies that are in the old manual here. Those links will take you there. I provided the background for you. This is information that we might normally put in an individual précis, for example. So you'll find here for 2304, since we're talking about that one, on July 16th, we adopted 7340, and the précis stated, there's a link to that précis, it will take you there on Assembly, that this policy, 7340, replaced policies 3000, 4000, faculty employee dress, and they were removed when we posted 7340. However, that policy happened to be in 3 places, not 2. And so 2304 is still hanging out in the old manual, right? So this is why we're asking that this policy be repealed. Same thing for the first one. Here are 2 prohibited conduct on school property and school events. We've got 2 policies here, 2212 and 3012. And in 2020, when we adopted 5021, we pulled down 4012, but we did not pull down 2212 and 3012. So we're asking for those to be repealed. And again, links in there, full transparency, everyone can see when it was adopted, what one was listed to be removed, what policy was listed to be removed, etc. So in this category, category 1, we've identified 4 categories for today. Well, let me first ask, do you have any questions about this? Yeah, please.
Thank you, Chairman. So again, just to repeat for clarity, every one of these categories that you have here you're basically repealing something that the board has already taken action
Correct.
to repeal. This is just a duplicate copy,
Yes.
or, a copy where, there was something added by mistake, and then the last category is just rules and procedures, which we don't put in the policy manual anymore.
Yeah.
Okay,
This is the only, category 1,
yeah,
right? And occasionally in our correlation table notes, when we talk about what policies get replaced, they didn't include all 3. We've got a companion document that says, okay, this policy is replaced by this new policy, but later on in the double or triple, whatever, the second or third number for the policy, it'll say delete redundant. It wasn't listed here. It is listed here.
and then as a follow-up.
Okay.
So then, and I know we looked at Wake County and how long our policy migration was taking compared to other districts and other counties, and a lot of it is that we were going through every single policy one by one. And here you have an example of, this should just be administrative, just a batch cleanup.
Right.
And so, if, again, we're not repealing anything we haven't already taken action on.
Correct.
I'm in favor of just moving on by a vote, accepting the recommendations.
Well, let me go through the other categories before you make that motion. but
Yeah, I
that
do
would
want
be
you to do the other
recommendation for
categories.
action then.
Okay.
But before you keep going, let me see, do the other 3 board members, do you have, Mr. Hershey?
To Mr. Harry's point, why do we have to vote on this versus you just, like, we do a new policy, the old one is...
I think that's a good point. This first category, I don't think you technically need to vote. This is just an oversight. There were cross-posted policies. You already voted to repeal it, and we could just do it. But at least one of the categories is a little discretionary. I can't remember which one. And Julie wants to mainly have you look at that. So, I think that might, when we get to that category, she'll explain. There is one where there's a little judgment that does require your approval. But I agree, that first category, staff could just do it, but we thought, since we're doing this cleanup anyway, let's just present it all to the board and
I
invite your
appreciate that.
feedback.
Thank you. Ms. Gordon? I'm good. And Dr. Ing? Okay, great.
So here's one in 2018. You can see that these are kind of historical through the committee listed them in numerical order. Personnel files, solicitation or selling, unethical influence. We have 7305 employee conflict of interest here, 4243 and 4260. Again, all of these sort of remained, they were kind of abandoned or orphaned back in the old manual, and they should have been repealed all at one time, been hanging out in limbo land. The second, do you want to take a motion for category 1?
2. No, category 2.
Category 2, these are repeals of old manual policies that were not initially identified as replaced by the new policies. So for the migration project, we have, I told you, we have these notes, right? These categories of notes. And those notes may not have identified all the policies that were being fully replaced. So we've identified right now 3 additional policies that were fully replaced by new policies and can be repealed. And so we're requesting removing these from the old policy. For 2500 public information, in 2019, we adopted policies 5070, 7350, and our tables indicate that policy 2500 was fully replaced. But they don't, but we didn't include that in our précis, and you didn't take any action to do that.
So this is the category I was mentioning. There hasn't been specific board action, but Julie and I have reviewed these and confirmed everything is superseded by the new policies. But we did want to, this is why it's important for you all to see this and be able to put on the brakes if you see anything that we should need to preserve.
Okay. Same with 3200, 4200. This is initial assignment of, I think, teaching staff. Yeah, teachers, yeah, initial assignment employees. We did adopt 7440, and our tables indicate that these 2 policies were fully replaced. So we're asking to remove those. 3210, 4201, this is specific assignment, another HR policy. Again, we adopted 7440, and our tables indicate that this one was also fully replaced. So here are 3 that were not initially indicated, but can be removed because they have been fully replaced.
And then category 3,
Category 3, this is a historical document, or this is a historical table, right? So initially, in July, the first policies, I think, in our manual, when we started the project, July 21, 2015, so coming up on 11 years ago, 10 and a half years ago, this predates me in my position. When we adopted or migrated a policy, we placed them in both the new manual and the old manual. Since then, we revised the policies, many of them, and we have not included any of the revisions in the old manual. We kind of double placed them. Those include 1510, 4200, 7270 school safety. They were placed in both manuals. 1720, discrimination, harassment, and bullying complaint process, also placed in both manuals. These were all done on July 21st, 2015. 1730, non-discrimination on the basis of disabilities, and 3225, technology responsible use. These 4 were placed in both policies, both manuals. We've only updated the ones in the new, so we request the repeal of the policies in the old manual.
I had a question about category 3, but you've now cleared it up for me, because I found a lot of this,
Yes.
you know, clear as mud, so to speak.
Yeah.
Dr. Taylor, did I see you had a comment? No? Okay. Any questions? Yes, Dr. Ing.
I guess for myself and for other people who may be listening and confused about old manual versus new manual, when is it pertinent, when is it not pertinent? And then with the repealing of some of these policies, is it active as of the day that we pass it, or is it active retro to some point in time?
Old manual, new manual. Let me address that question first. So let me show you, when you go to our policy manual landing page, you get an explanation. Hey, we have 2 manuals, right? We're going through a migration project to, and our explanation of that is we are mirroring the North Carolina School Board Association's policies to lead the schools manual. So we are bringing our policies in alignment with them. We are signed up in their update subscription, so they let us know when their policies change. Based on statutory changes, et cetera, they may have some changes that reorganize. So we receive those. As we migrate policies from the old manual, we put them in the new manual. I wish we had different names, old and new, right? But this is what we have. And you can click on either one. We do have some explanation here that if you're in one manual, you will only search in one manual. You won't get results from both. It's on one or the other. And note 2 says that there's numbering conflicts that might result in things being partially replaced in one. We didn't strike through text. It might be confusing. If you know the number, type it in. You can go there. And if there's a discrepancy, follow the new manual. Unless it's not in the new manual, then follow the old manual. Right? I mean, it's kind of, but we are moving to a point now. So today, for example, all of those double and triple coded policies, I think I told you there were like 238 items in the old manual. We're removing 10% of what's in there today. And I want this to be a recurring item on our agenda so that we can continue to remove. We're down to, as we finish up the 7,000 series, what remains are the 8,000s and 9,000s, finance and facilities, construction. And there are much fewer policies in those series. So we should be able to go back now in our old manual and really remove, clarify, these are all done, let's get rid of these. So that's the answer to that one. When is it effective? if a policy has been migrated to the new manual, the new manual policy is the one that we follow, effective, it's when it was initially adopted. So the policies in the old manual they're not applicable because they're superseded by what's in the new manual. Removing them will help confuse that, will help remove that confusion. Does that answer your question?
Yes.
Okay. Yes.
Thank you, Chairman. So I thought Dr. Ng's question meant something else. So if he's satisfied, I'm going to re-ask it, but ask it a different way. Because this is really breaking my brain. What purpose does maintaining the old policy manual serve?
We have policies that have not been migrated yet. They are in the old policy manual. So if we click into the old policy manual, for example, our 8,000s are primarily still here. All of our undesignated fund balance.
So they're current policies.
These are current policies, yes.
They're old but still current.
Yep.
Have not
And-
yet been replaced with an NCSBA modeled policy.
Okay. So if we have policies in the old manual that are still good policy but haven't moved over, again, this is why we do the migration, and why we need to expedite the migration and get them all into one manual. Why is anything else in the old manual other than policies that haven't migrated yet? Because looking at the website that you had that explained it, it seemed to look like the old manual was a historical record. This is what our policies were before a certain date. If I wanted to see what the conduct policy was before 2015, it might be in there, but that's not what it is. And I think that's confusing from the definition or the description that's up there. So is the goal here just to have a remainder manual that only has the policies that haven't migrated? Because if it is, it seems like everything that's migrated should be out of there.
Correct.
Okay,
That is the goal.
okay.
In the end, one manual, one brain to rule them all. One manual, right, in the end. So there will be nothing to remain in the old manual. Everything will be in the new
I
manual.
mean, if we could visualize this in the old-fashioned way, it should be a binder that we're ripping pages out of until eventually there's no pages left in the binder.
Yes.
Okay. So-
Staff and I have had a conversation about whether or not it might even be possible, once we're down to the last, the 8,000, 9,000 series, whether or not we merge the manuals and put an asterisk in the policies. They're going to look like they're in the wrong place, right? Like, I'm looking at a capital outlay fund or board authority to override rejection. That may need to go in the 2000 series when it's migrated, because that's where our board operations are in the new manual. But it's got an 8,000 number. So I could put it in the 8,000 series and put an asterisk by it, or I could put it in the 2000 series and put an asterisk by it, right? So we have some options to consider. But our first step was to bring it to the table for discussion, let you know what we're aware of and what steps we're taking to clean that up, so that ultimately what remains is only what needs to be migrated.
Okay. Okay, thank you.
So, Madam Chair, if I could add to this, and I know what Mr. Haggerty is kind of alluding to, because we've had this discussion about the length of time. And so if you could, as an example, think about those things that you say, for example, in the 8,000 series. So if there is not a sample policy that the School Board Association has, it's something that's specific to Wake, then is there some reason that we couldn't just migrate that to the new policy manual, because there's not a comparable policy, and even though we would go through the numbering nomenclature, if you will, would that not expedite it to where you and you said all those things that are in that old manual, if there's no equivalent policy, is there some reason we would just move it all and not have this dual manual?
That's a good question. What we have been doing is, as we migrate policies through the series, we have mainly stuck to the series that we're working on. And when we come across a policy that is WAKE only, or WAKE specific, we make sure it has the right number to go where it's going to go in the new manual, right? So if it's an 8,000 in the old manual and it's going to go over to the 9,000 in the new manual, we make sure it gets the right number and doesn't overlap with any number that's in the School Board Association's manual. And then staff has an opportunity to look at that policy to see, is this still current? Does it still reflect practice? And they have an opportunity at that point, kind of here's the opportunity. You were going to revise this. Would you like to revise this to reflect current practice? They have an opportunity to do that, and then we move it through the process of policy committee, et cetera. Is there any reason why we couldn't just go ahead and move things over? No, not to my, I'm looking around the room to see any eyebrows that might be up or concerned about that possibility.
Mr. Swanson, did you have a question?
I did, thank you.
Sure.
So I'm playing around here as well and just looking and understanding the difference between what's in the old policy and what's in the new policy. And so if someone that's looking that has a grievance is trying to follow the policies, in order to understand what's been modified and what's currently on the old books, you have to click down and do some clicking. So I'm wondering, is there a way, and this, just to simplify in the old policies or on the website, whichever ones have already been updated, there's an asterisk that says, see the new revisions. So someone as in the public can understand and has a deeper understanding, because not everyone, even if they're listening to this, understands or knows. They just know, number one, I have an issue, board policy says this, and if I'm following the old manual, then it leads to more frustration, more loss of the trust with the public. So just trying to find a way to streamline this process so the public understands which policies are applicable as they're going through this migration process.
Part of what this batch process is intended to do is remove that confusion, is to acknowledge, hey, we got things in two places. We need to get that out of the old manual. It's already been repealed, or it was double or triple coded and we didn't pull it down before because we didn't realize that information was in three places. And I've been doing this for a little bit and I can't decide if it's just that complex or I'm not that bright to not have kind of noticed this before, right? Like, you could read that either way, but we can do some of this work, and let's go ahead and get as much of that out as we can. We brought you, again, I think it's about 15 this time that represent 23 items of 25 of those 238. Next time I'd like to, this is part of my work every day now, is to chart and track what's in the old manual, what action have we already taken, what was in the correlation notes, what's in the delete redundant notes, to make sure that they fully overlap, and we know, no, we need to take this one down. It was double coded, triple coded. It wasn't identified first. Can we simply pull it? We don't touch the policy manual. These are your policies, so staff doesn't just willy-nilly go in and change things in the policy manual. We need to do it with your being informed.
Follow up, Mr. Swanson.
Yes, maybe I'll reframe it a little bit differently. I understand and I appreciate the work that's been going on to, clean up and make things easier and delete or get rid of redundant policies. But on the website where folks go to understand and figure out how WCPSS operates as a whole, it's through these policy manuals. And so if it says old and new, and I have a grievance and I don't necessarily know who my school board member is, but I'm clicking through and I'm looking at the old one that's still active and live, and then looking at the newer one that hasn't gotten there yet, just trying to find a way, how do we streamline some of the confusion? Because only way you can understand that there's been some revision if you click down and read where it says revised policies are here, and it gives you all the list, but again, a parent is not going to go through and do all of this deep dive. Their concerns are, I have an issue, what does the policy say, what do I do? So I'm wondering, is there a way on the new, manual, maybe we or not activate some of those links, but, make it so it's not necessarily live for folks to click through, so it pushes them back to the new policy, so it eliminates some of the confusion. So I don't know how and what that can be done, but it's just a...
To my knowledge, at the moment, of the functionality of the online manual, what we would need to do is to go in and inspect, this is just spitballing what we could do, is to go in, for example, right now, in the 1000 series, on the list is 1510, because it was placed in both manuals back in 2015, right? If you click in to this policy, you'll see, you scroll all the way down, July 2015. Only the new manual one has been revised since then. This is why we're asking for this one to come down. I would need to go into the very top of the document and say, this, add text underneath the title, this policy is not current. Please see policy, insert the same title, and hot link it. Hot link, there's a phrase from the early 2000s. Link that to the new manual to direct them to the current one. That's the solution that I can think of at the moment, once I click in here, unless...
You mean prior to the board approving the deletion of the superseded old policy?
Yes.
So I think that's the rub, is that staff are just reluctant to go through and say, oh, I think this has been superseded, I think this has been superseded, let's just delete all the clutter. Everyone wants that end goal, but I think Dr. Crane's approach is, let me give a chart to the board so you can in batches start cleaning up the clutter, as opposed to making the decision herself and hoping that you agree.
So, this is along the lines of Mr. Swanson's question and this spitballing of ideas. So, I believe I understood you to say, Mr. Ramey, that technically everything under Category 1, at least that category,
Yep.
staff can take care of without
I
bringing it
believe so.
here.
The board already voted on those, correct? Yeah.
Okay, so can we just say for, move forward?
Yes.
Anything that falls under Category 1, even if it's not on this list today, move forward and take it down?
Yes, absolutely.
If we approve the rest of the request in Category 3, Category 2, Category 3, and Category 4, which, by the way, Category 4 is R&P, which we technically don't approve, vote up or down, but I'd be willing to do a Category 2, Category 3 list again, at the next policy committee meeting, but I'd really like to see if we just, give you the thumbs up to just start, and anything hitting that Category 1, just take care of it, how quickly we could get, this down, this confusion eliminated. The other thing I want to encourage, direct you to do, if my colleagues agree, is I think it would be better just to have the new policy manual listed, and the ones that we still have to migrate, have that in some kind of appendix or something within the new manual, and just get rid of that old manual language and old manual link, because I agree it's confusing to the public. And to your point, Mr. Swanson, a parent that's frustrated, I don't even know that they're going to read that top paragraph to explain. I mean, we're doing our due diligence, but I don't know that it's effective. And especially, we're so close, Yes, Dr. Green.
Yeah, I just want to add on to it. Also, when I clicked into the old manual and the new manual, it doesn't say on the top whether it's old or new. So once you kind of get into the weeds, you kind of get lost. Is this the old manual or the new manual? You really can't tell. So I think it would be wise to reduce the confusion somehow, whether it be removing the links to it or combining, or like what you were saying.
I mean, I'd much rather you spend your time that way than trying to go in the old manual and have typing, even cut and pasting a sentence, this isn't relevant, like, that's not, I don't think that's the way to.
So what I hear from the board is that for category 1, go ahead and do that.
Yes.
You don't need, would you like for me to bring you a list of these, or just do it?
I don't need a list. Board members, what do you,
I don't know.
I mean, if you're
Put in
working,
the agenda as an information thing that you could read or not. I mean, just to, I like the idea of keeping the board updated, you know.
that's fine, but if council agrees
Yes.
that it's in
Board actions
category
already been
1,
taken. Yes.
with that caveat, between your conversations, I don't need to approve it.
Okay.
If it's category 1.
How about category 3? I'm going to ask because category 3 is where policies, and in those first 6 months, I found others in August and September and October of 2015, where initially many policies were placed in both manuals. But only the new version has been revised.
Gotcha.
So we have that initial version of a policy in the old manual that, yes, has the same number and has the original adoption date, but from that point forth, right? Would it be okay to remove those and
Yes,
make that an
and-
information item as well?
I think so. Again, if any colleague objects, please, say so, but I think so because to me it's so similar to category 1. And again, as long as council agrees that that's, appropriate and within,
Okay.
your authority. Is that,
I think that works. We
Okay.
can put our heads together, and we'll just, each meeting, give you a list of what we've done. If you have questions about it or want to revisit any of those, we can always restore them.
that's fine. So we will continue to have some discussion, if necessary, on anything in category 2.
Correct.
Yep.
Board members, does anybody have any questions about what we're directing staff to do? Good. And then do let us know about that, the idea of taking the remaining that's still to migrate and just putting it in the new manual with some type of, I don't know
Way
if
to
appendix
note-
is the right
Way to
word.
note that.
Yeah.
There's a way to note, right, either go ahead.
And I
put
think
them-
I think they should be in their own section rather than dispersed throughout the number categories, because I think that will be clearer, to a member of the public.
Microscribe is the company that hosts our manual, and I know that they recently had a significant update of what they offer. I don't know all of the operational possibilities for how our manuals are hosted, but I will come back with a path forward. Mr. Swanson, I really hear your concern. We want family members and our community stakeholders to be able to find what they need without confusion as quickly as possible. That is part of our core business, right? In the teaching and learning and the operation of that endeavor, it is in everyone's best interest to make sure that access to these policies and RMP is as smooth as possible. It serves everyone's interests to do
So
that.
I'm glad that you brought this to us today, because while it's kind of clunky, I think it does make progress on, because that page has been sitting like that for, as you said, 10-plus years. Mr. Ramey, can you help me with a motion that we might
Sure.
need to move to our next agenda
Well,
item?
if you're all comfortable with all of the recommendations here, you can have a simple motion, one single motion to approve all the recommended changes listed in the agenda. So
Okay.
it'll reference the agenda that way. If you don't, if any of you are uncomfortable with any of the changes, we can vote separately, so that every member has a right to divide the question. You can't be forced to vote on the slate, but if you're comfortable with the slate, one motion to approve the entire slate is stated in the agenda.
Sure, okay. Mr. Hershey?
Motion to approve the entire slate.
Second.
All right, there's a motion and a second. Did you get? All right, all in favor, please say aye. Aye. Any opposed? Great. All right.
I realize that was really in the weeds, and I really appreciate you walking through that with me and giving us some direction. as we move through how to make sure everything is covered, take care of everything, and move forward with one manual.
Yes, thank you. No, I think it's a step forward for sure. Thank you.
You're welcome.
All right, we are going to move to 1740-4010 student parent grievance procedure.
Yes. As we move into these revisions, many of these revisions were made to, again, stay aligned with the School Board Association policies and their policy manual. So, for example, in policy 1740, these revisions reflect their model policy. There are clarifying definitions or additions throughout. So, for example, on page 2 of the policy, they added a definition of parent, and their effort was to clarify, we're going to say parent and not add parent guardian. So throughout their policy, they included parent, and then they struck guardian. We know the board's preference to keep the guardian language in there, so you'll see that definition of parent there in red, School Board Association language, and you'll see a lot of guardian in blue, and that's where they had struck it, and we unstruck it to leave it in there, to preserve that language. There was some, again, here's this little, a failure by the school system, et cetera, just clarifying language throughout there. In section D, the general requirements numbered item 2 states some language that makes clear that we are compliant with open meetings law, so that all of those meetings will be private unless the open meetings law requires a board meeting or hearing be open to the public, and it lists those policies there. We do have those policies in our manual, so there was no need to do any of that. And item number 5, we made some changes here. They added a sentence at the end that said at any meeting or hearing during level 3 of the grievance process, a student grievant may be accompanied by a parent as well as a non-parent advocate or attorney. This policy addresses student and parent grievance procedure. So in working with Neil, we clarified that language a little bit, struck that sentence that they recommended, and stated instead that a student may be represented or accompanied by a parent, non-parent advocate, and/or an attorney at the level 3 hearing. And then we clarify a parent may be represented or accompanied by a non-parent advocate or an attorney. Now, I made sure with Neil, this language does not expand or change anything we already do. It's simply a clarification to make sure that we are clear that a parent can accompany a student at that hearing. Here you'll see some more guardians. Put in here the student or parent, because ours is both in this policy. And then at the end of the policy, well, we didn't need to add any references. That's the conclusion of the revisions in that policy.
So Dr. Crane, just what stands out to me is that in that, I guess, letter D, number 5, it needs to say by a parent/guardian. And then just, it doesn't matter to me, but up above, we have parent/guardian, and then throughout below, it says parent or guardian. Just pick one and make it consistent. But we all do appreciate that Wake County Public Schools is leaving the term guardian in there. That's important. Board members, anybody have any questions? Yes, Dr. Ng.
In letter E, D, sub-level D, should it also be parent/guardian, right?
Is that D?
It's in the last D in...
E1D,
Oh, E.
I'm sorry.
Almost too far.
Yeah, the one,
Page 4. Oh, yes, yeah. Even if the principal is the employee whose decision is at issue.
Student or parent/guardian, yeah, that's another one. We could, if it's okay with the board, you could just direct staff to consistently refer to parent/guardian
Yeah.
throughout the entire policy.
Correct.
Right?
Correct,
Okay.
yes.
My understanding of that one has to do with the title of the policy, which is student-parent grievance procedure. Do we need to include guardian in the title of the policy?
I mean, substantively, I think you're covered because you defined parent to include parent, guardian, legal custodian, someone who's enrolled their children under non-parental affidavits, the whole to caboot. So I'm not so concerned about the title, but you could. It just becomes a little clunky as we add / designations in the title.
Mr. Hershey?
A couple of questions. Under the process for grievance, filing a grievance, letter E, I'm wondering what happens when we don't have, E and then 1B. It says, all grievances must be submitted to the school principal, except grievances regarding transportation issues should be directed to the senior director of transportation. Go up. I think I'm on page 3.
There it is.
And then number 2 says to the chief of staff, what if we don't have, I mean, we just had a long period of time where I don't think we had a senior director of transportation because we were hiring, though. What if we don't have, since we're naming specifics, what if we don't have that person in place?
And that is always the risk of putting specific job titles in policies, in my opinion, because they do change and sometimes you have vacancies. So at your discretion, I mean, we could revisit that and come back with, thoughts on ways to address it. I do think that senior director for transportation has been correct me if I'm wrong, someone from HR or something, it's been a fairly stable position for some time. Senior director for transportation, I believe that's been around for.
Didn't we just hire a new?
Yeah, you have one now.
So we had a.
You had a retirement and you had a short gap and then you hired a new one. There was a period of time.
We, in that interim, when there was nobody there, we did some lower level staff reviews, and then they came to me. And then if they went after that, I would send them up to the superintendent. But we didn't have but a few.
Yeah, so just raising that point, I would be in favor of changing it so policy is followed, but that's up to the discretion,
Mike, to follow up with
Yeah.
Mr. Hershey, or to your point, Mr. Hershey, my concern is that people don't know who the senior director of transportation or chiefs of staff are, and it's hard to find those actual names and contact emails. If you're a parent, if you're a member, parent or guardian, those are not at your fingertips. And so I have concern about that too. Mr. Swanson?
Thank you. So I have two concerns or suggestions. I agree what's been shared thus far with the, naming those specifics. So I'm wondering, I'm a little concerned, you have the senior director of transportation in 1, and then you have the chief of staff listed in 2. So how do we make that consistent so it flows better for folks? So I'm wondering if we're keeping it at the chief level, should the grievances for transportation be directed to the chief facilities person? Trying to get your...
That's what it goes to the senior director, and then they come to me.
Appeal. Yeah.
Gotcha. So, getting it mixed up, but I did thank you. I did have a question. I was going back to our retreat when Attorney Sorkis brought to our attention that some of our policies were not consistent with Cumberland County, and I'm looking to Mr. Hector to see if you can remember some of those discussions. I was searching Cumberland County's policies where they actually talk about the types of the grievances, how many panels are supposed to, board members are supposed to be there, which came from the School Boards Association, but our language did not mirror what theirs was. So I'm wondering, since we are discussing the grievances, it would be applicable to add this discussion there as well. That was in our December, was it December retreat? Or?
Yeah, it's in those materials. Are those in assembly? If so, I can.
They are.
Okay.
Let me see if I can pull those up.
I'll take a look too.
Dr. Crane, what's our time limit on this one, on 1740,
So I still had
4010?
I have another question.
Okay.
These revisions are not time-bound.
Okay.
They are an effort to make sure that we are aligned. There's no required by statute adopt date.
Okay, great. Mr. Swanson?
Sorry, I'm all over the place, but
That's okay.
I do know that, I think it's also important, since we're talking about the grievances here, that, we are also mindful that maybe teasing out in policy the timeline, because I know that has been a concern, a major concern, that when I was vice chair, I had lifted up, and when Mr. Haggerty was the chair, that those were two concerns that he and I were consistent about. So wondering, how do we roll that out better? And how are we communicating to those individual family members? If policy says 20 days or 10 days, you should not wait to day 20 to then say, I need 5 more days. Just make sure that we're consistent and folks know how to follow that timeline, so it eliminates any of the misunderstanding or frustrations that families have. Because clearly, if they're filing a grievance about something, they are already at their wits' end, and they've reached the last place where they feel as if they can get some type of justice. But just ensuring that we are following those timelines accordingly.
So what I can add to that is we've gone through and made consistent the records that are at level 1, level 2. Part of what we've run into is that we may have something that reaches a level 2, they don't have a level 1 grievance. So anybody that's at that level, they are required to now do that. We have a system where we're putting all of those in so that we can now know when those issues come up and we can avoid those 20-day timelines. I think the board has been explicit that if something comes and the person has exceeded that timeline without good due cause, then the board is going to rule accordingly. But those are the things that we've put in place to make sure that logistically those kinds of things don't happen again.
So would that also require some changes in language and policy? So families, because we sit on many, I know the former chair and I sit on many where that was brought back up, and so, and they're quoting policy back to us. So if it's there in policy, just making sure that we are,
Yeah, and I know one of the things we talked about was dates that may be in the policy, and some of it can be ambiguous, if you will, because it'll say that administration has 20 days unless additional time is needed. And then there's the question, is additional time 5 days or 5 months? There's a difference there. And so, there's always the opportunity to look and see, do we want to have more explicit language to say, if there's an issue, we extend it to 30 days and that's it, or something else in between that would better define what additional time would mean. What I've said to staff now is that even though the policy is what it is, any additional time that you need, that has to be cleared with the superintendent, so you won't end up going 3, 4, and 5 months. But that can always be spelled out in policy if the board desires.
Any other questions, comments? Yes.
I was waiting just, because I know Mr. Hershey had something else
Yeah.
too, but is it also related to the time?
He basically covered it. It was just, do we have information on whether we've been meeting the 30-day time frame, or if we've had time lapses? But the chair covered that, I think, adequately.
Well, I'd like to build on that,
Yeah.
just because since we do have the policy here before us, this is an issue that has come up, as Chair Swanson has cited, and we do not have a very good track record in terms of meeting what's in the policy regarding these deadlines. Now, the other side of the coin that we don't often talk about is oftentimes these cases are complex. Oftentimes, to give them a full hearing, we may need witness testimony, or we might need to go back and ask more questions, and people that are connected to a dispute but not part of it may be reluctant to participate. Sometimes the person filing the dispute may not be timely in responding back, but nevertheless, we end up exceeding these deadlines. And so I really think there is some value to revisiting some of these deadlines and perhaps giving them a modest extension. And to the point that you raised, there are some, and Chair Swanson mentioned this, there are some protections in place, which says, well, we'll meet this deadline unless more time is needed, but then we're supposed to have a formal process of making sure that the grievant is notified. But what form does that notice take? Is it an email? How do you go back and verify it? And then, is it, well, we need a couple more days, or the person that we need to talk to just left the state, So it may be too much for us to talk about here today, but if there is sufficient concerns, the ones that Chair Swanson raised, Mr. Hershey had mentioned, I share those as well. We may want to bring this back just to look at those timeframes, the volume of grievances and hearings that we have, the system that we have in terms of who hears them. I think there are times of the year when, they don't have a lot of time to hear these because of other pressing issues, but that doesn't diminish the importance of the appeals and the grievances. So I would like to bring it back, and maybe let's have some discussion input around those deadlines.
So,
I'm fine with that.
Madam
Yes,
Chair, if you don't
yes.
mind, I will direct staff to begin to look at how we can formally document time extensions, because like everybody else, I think when it's written in policy, it removes all of the ambiguity. So if there is some time extension, we have a policy that governs what that looks like. So, we'll have you guys to work up some language, and then at whatever point we feel appropriate, we can bring it back and hammer it out from there.
I can add one thing too. I've had some initial conversation with staff about other ways we might be able to simplify and clarify the process. I know because you have multiple policies that allow for appeals, it's kind of confusing to even navigate and figure out, is this a grievance, a complaint, a bullying and harassment complaint? So we have been strategizing some on that, and what I would envision is at some point, I don't know if you might want to do this first, addressing the extensions of time issue first, but I do hope that we can get more of a form-driven process, complete this form. If you fill out, depending on how you answer question 3, it's a grievance or a complaint, for example, so we don't have to, because I think a lot of the problems working with principals, area superintendents I've noticed, are everyone gets a million emails a day. Some of them are complaints, some are grievances, some are bullying and harassment complaints, some are something else. Some are just emails, and they're not labeled and captioned, and it's not always immediately clear what you're dealing with. So I'm hopeful that maybe some forms and kind of processes outside of policy will help with some of this as well.
Okay, thank you. Yeah, Dr. Green?
And then to add on to that, I mean, if you have a form that you could potentially build into it a timeline reminder
Exactly.
for both parties.
Exactly.
That way, everybody's accountable to that timeline, right? So,
That's my thought. The form would get this information that's required to analyze what it is, and also would build in some information for all parties about when responses are due and things like that. So.
Thank you. Board members, I want to set expectations. It's 2:01, and I really, really want to be sure that we get to capturing video on campus. We've bumped that twice, and so I want to make sure that we've got time to discuss that at the end today. So,
Clarification, may we move forward with the revisions on?
yes. I mean, I didn't think we needed to take a vote on that because we want you to bring it back. So is that, we don't need a formal vote to do that?
So wait, don't move those revisions forward, or just wait and do the additional revisions
I mean,
later?
if we're bringing it back, I'd say, make the revisions,
Bring it back.
but we're bringing it back, because we want to discuss these timelines and insertion of new language potentially.
All right.
So, does that?
Yep,
Yeah.
I'm clear now.
Okay.
For our next policy, another School Board Association revision. This language, the red that you see.
Can you state that it's 2125, correct?
Yes, this is policy 2125, 7315, confidential information.
Yep.
There's some reformatting, some headers that have been placed in. Section A is now personnel files, no changes to the introduction of the policy. Section B is an addition, it's student records. This is pretty simple language that just says we'll safeguard the confidentiality of student records and points to our policy 4700. A new section is section C. This section is required by law now. New statute, session law 2025-79, creates General Statute 55A, Article 18, that says employees and board members shall not, one, require any person or nonprofit organization to provide personal information or otherwise compel the release of personal information. Two, release, publicize, or otherwise publicly disclose personal information of others. Three, request or require a current or prospective contractor to provide a list of nonprofit organizations to which the current or prospective contractor has provided financial or non-financial support. And so for the purpose of this policy section only, personal information is defined as any list, record, register, registry, roll, roster, or other compilation of data of any kind that directly or indirectly identifies a person as a member, supporter, volunteer, or donor of financial or non-financial support to any nonprofit organization. And then it goes on to talk about the terms supporter and volunteer do not include the nonprofit organizations governing board members, officers, directors, or staff.
So this was a big red flag for me. And I know we've got another section that's new, but we have had board members, nobody on this current board, but in the past, there have been board members who have served on a charter school board or a private school board. Is this saying that current, sitting board members can no longer disclose that information? If we become aware of it once we are on the board, are we prohibited from, disclosing that fellow board member so-and-so, serves on a charter school board?
I think that this is, first of all, it's statutory, this provision, and I can pull up the statute, but the NCSB language kind of really hugs it pretty closely. It's only personal information that can't be produced, and that's defined as any list, record, register, registry, roll, roster, or other compilation of data that identifies a person as a member or supporter. I think it's like membership lists. I don't think it would prohibit, certainly wouldn't prohibit a person to self-disclose that they are a member of a board.
I'm not talking about
Are
self-disclosure.
you talking about membership lists? or-
Yeah. Well, not necessarily. I mean, it was known at that time that the sitting chair of the school board was on the board of Thales Academy. So a board member at that time could not disclose that. But that doesn't mean the whole...
Specifically, it says that this doesn't include their governing board members,
Yeah.
officers, directors, or staff. But if they were a volunteer at a charter school or gave money to support charter school movement, it does, does this read and say that we cannot compel or reveal that information?
I mean, I'm specifically asking about service on a board, because I understand there's more, personal information, a donor record, et cetera. Anyway, I just had that specific questions because in my opinion, it is relevant for the public to know that because I see that as a direct conflict of interest serving on a board of public education. Mr. Haggerty.
Thank you, Chair Edmonds. So I understand that this is statutory and that we're required by law to place this, but to Ms. Edmonds' points, there are some red flags here. And I'm curious, Dr. Crane and Mr. Ramey, for your legal analysis. I understand a policy that would prohibit employees and board members from requiring anyone to disclose information. That's C1. And I would understand C3, requesting or requiring a contractor to provide information. But I don't understand the constitutionality of C2 that would prohibit any employee or board member from publicly disclosing personal information, which doesn't seem to be protected information, it doesn't seem to be confidential information. It just says personal information. Personal information is defined as any list, record, registry, roll, or other compilation of data. which could be public domain, that just really seems to, I think, infringe on free speech rights, that we have a policy and potentially a state statute that says I'm not allowed to disclose that someone's a member or supporter of an organization. Again, I can understand where we can't compel someone to release personal data, and we can't request or require a contractor disclose it, but that there's a difference between compelling someone else's speech and restricting my ability to share publicly available information.
If I may piggyback on that, I mean, I'm outreach director I'm employed by a nonprofit, and my name and title is on our nonprofit website. I know the same was true for Ms. Johnson Hostler, in her role. So that's the kind of thing that I'm wondering about. And again, thank you, Chair Haggerty, for clarifying. I hear you, it's state statute, so we have to adopt it. I got it. I just want clarification, so that we know.
Unfortunately, I don't feel like I'm in a position to give you a clear opinion on the statute, especially its constitutionality right now, but we can, I don't think this is urgent, that we don't have a deadline to adopt this. This is one of those things where NCSBA puts the summary of the law in the policy. You just have to comply with the law. You don't have to have a policy that says you're going to comply with the law. So I think it would be perfectly fine to hold this, give us a little time to review it. We can maybe do some legal research and come back and talk to you about it again.
That'd be great. And to try and honor my own timeline that I've given for today's meeting, Dr. Crane, can you go ahead and walk us through Section D?
Section D adds some language about establishing and enforcing processes and protocols for secure handling and electronic transmission of personally identifiable information of students, employees, and other information protected by state or federal confidentiality laws. So that's an addition there. We also added, I believe we added that language to our policy 3225 recently, technology responsible use regarding the safeguarding of PII, personally identifying information. And then we've got in our legal references the addition of that General Statute 55A, Article 18, and another resource from DPI regarding transmitting private information electronically. Yeah, thank you. And we'll bring this one back.
Yes. So with that understanding, board members, that this will come back to us. Does anybody have any comments or questions before we move on? Okay. Thank you. Next, we have 7305.
7305. Employee conflict of interest. And adds a new section F titled Training. Remember, red language is School Board Association, blue is our staff, and anything in green is simply a move. So in creating a new section F, we removed a piece of language was removed. The superintendent or designee shall ensure that all personnel are aware of the requirements of the policy and any applicable conflict of interest laws. That becomes the first sentence under section F. And then the new language references General Statute 115C-335.15 that requires employees who are involved in the making or administering of contracts shall receive conflicts of interest training. That includes position-specific education on conflicts of interest and ethical standards of conduct. The School Board Association recommended the language that said the training must be provided by qualified sources approved by the board. We already have this training going. It is provided internally by our finance officer, Trish Posey, who has revamped this training, provides it for us. We are compliant with this requirement. So we found better language might be the board authorizes the superintendent or designee to select qualified sources to provide the training.
Mr. Hershey.
I don't know why we even need that, because the first sentence says the superintendent or designee shall ensure that all personnel are aware of the requirements. That, by the language, is us telling the superintendent to do it. So
Okay.
personally, I think the sentence in blue is just repeating.
I think This sentence, actually, this first sentence here is statutory language. Most of what we get from the School Board Association really does hug the statute really tightly.
I mean, that's fine.
The blue was a way that we could kind of make it apply to us, but if you think that we don't need that, we don't have to.
The statute says that the training may be provided by any qualified source at the choice of the local Board of Education. So you can designate what specific training, but it's also perfectly appropriate for you to delegate that to your superintendent. And I agree with Mr. Hershey, the policy generally does that anyway. This is just a specific point as to the training.
Mr. Henry?
Thank you. And to Mr. Hirsch's point, it's the deleted language, I think, about otherwise requiring that we would have to have a board vote every time
Right.
to approve it, that I think the new language modifies a bit.
That's fine.
I need a staff interpretation. Throughout the policy, this is employee conflict of interest. It says employees. Are board members considered employees for purposes of this policy?
We have a policy in the 2000 series, I believe. Let me, we're going to live check my memory here.
Old manual or new manual?
Manual. It's in the new manual. We have 2121, board member conflict of interest.
Would you mind pulling that up for everyone?
And that's actually listed in this draft, in the new Section G violations. It
Any
references-
individual, yeah.
It references policy 2121.
I would say unless it's a defined term, which I wouldn't be crazy about normally, board members are not employees.
Right. That's what I would have
You
assumed.
don't get W-2s, you're not employed by the board, by yourself.
So I'm just wondering about the specificity of the employee policy versus the employee policy, because I think there's good guidance here in the employee policy that we'd want to make sure that board members also adhered to. And I just didn't know about trying to bring those into alignment.
I would like
But
to,
I could do an analysis if you would like. I could do a what's in one versus what's in the other, where there are overlaps and what's different.
Just curious, Chair Swanson. if you-
Yeah.
yeah, I mean, I definitely agree, but I would like to, at some point, bring back policy 121 and really spec out and tease some things out, including, not just the conflict of interest, but expectations in addition to required training for ethics as well. So if staff has to go through additional trainings every year for ethics, I think board members should do the same, given the fact that we're dealing with highly sensitive information, and maybe putting some language around that if board members do not do ethics annually, participation in closed session may, something along those lines. I don't know if that could be done legally, but just trying to find ways to hold board members to the same level of accountability as we're holding staff, because we should model that behavior.
Thank you.
Yep.
And that doesn't delay any action on this.
Right.
Thanks.
Right.
Okay.
Any other questions about 7305 conflict of interest?
Right, so can I get a motion to put 7305 on the consent agenda for March 17th?
So moved.
Is there a second? Second. All in favor, please say aye.
Aye.
Any opposed? Okay, thank you. 7503 teleworking.
This is a minor clarification at the end of the policy that makes clear that teleworking, rather than referencing employees with disabilities, referencing teleworking as an accommodation. It removes the word disability and references that telework could be considered a reasonable accommodation. Request of that will be reviewed and evaluated pursuant to Americans with Disabilities Act, as well as Pregnant Workers Fairness Act, PWFA.
So I think this is largely a clarification because being pregnant is not a disability. So this is just to clarify, there's two reasons you can request an accommodation.
And again, legal references adds that to the end.
Any questions, board members? comments. Okay, can I get a motion to put 7503 on the consent agenda for March 17th?
So moved.
Second.
All in favor, please say aye.
Aye.
Aye. Any opposed? Okay. 7910, retirement.
The revisions that you will see here primarily are made by the School Board Association, and that is this paragraph here that staff has struck. And our attorneys have advised that we can substitute in its place the language that you see below it in blue. This references General Statute 135-4 and -5 regarding the board's responsibility or not.
Lack thereof.
Lack thereof, to cover a benefit reduction unless expressly agreed in the employee's contract.
I'll say it took me about 35 to 45 minutes to understand the NCSBA language. My colleague Steve Rawson gets the full credit for rephrasing it in a way that makes a lot more sense, I think. It's an accurate summary. This is all based on pension spiking, new pension spiking rules that for a certain category of folks who have pension spiking assessments, the retirement system can actually reduce their benefits, not just ding you all as a board, but also reduce the benefits. And the statute says you have the option to cover that, but you don't have to. So the recommendation is that's an unfunded liability that's very difficult to assess. So the recommendation here is not to do that, but simply to make the statement in the policy that the board will not cover those discrepancies.
Mr. Nieder.
Mr. Ramey, to clarify, is this for any employee that would be hired by the Wake County Public School System after January of 2015?
I'm not sure about the actual date. This is a relatively new statute, so you may
I
know more
believe
than I do,
it
but the
is
effective
for
date.
any employee that the Board of Education would hire after January 1 of 2015. And the original intent, or the initial, any employee earning more than $100,000 a year, but that $100,000 has been indexed. And now by 2020, it's up to like $130 or something, $1,000.
Yep.
And again, if the school board were to receive a pension spiking invoice based on the statute, the board could pay it, or they could say, no, we're not going to pay it. And then the employee or the retired employee has an option. They can either pay that pension spiking invoice themselves and then get their full retirement, or they can not pay it and then get a reduced retirement benefit. That said, any employees hired by the district prior to the January of 2015, Wake County Board of Education still will have the obligation to pay that pension spiking invoice.
Thank you.
That's my understanding.
That sounds right.
I've not studied the law extensively.
It also is this would only apply to the top 3/4% of folks who are capped. So it's not likely this would come up very often, but it could.
Yep, Mr. Hershey.
Do we need then to put that information in this specifically? Because that doesn't have a date on it, and Mr. Nieder just said it's necessary.
I think this is good. I can double check, but I think, because we had colleagues who have handled the pension spiking litigation have reviewed this and think it's good, and we've had other boards have adopted this language, but I can certainly go back to check. There needs to be any clarification on date ranges. I think it's good to apply prospectively.
I just agree with Mr. Hershey's concern. If someone's looking for this for guidance, it looks like this is a blanket.
Yeah.
We will not pay regardless of hire date.
Yeah, will not cover the reduced benefits of the employee. If you get assessed a pension spiking assessment, you have to pay it or settle it or sue the retirement system. Those are your options. This is a little different. This is if the employee's benefits are reduced, which is only going to happen to potentially in some small subset of people who are subject to the cap.
then this is just clarifying so that there's no misunderstanding down the road. The board is not liable for that reduction in benefits to the employee, so you don't control. That would be done by the retire system. So I think it's an accurate statement, but happy to review to see if there's any other clarification that would be needed.
Chair Swanson, I hate to put you on the spot, but would it be okay to put this on the action agenda for March 17th so that staff can answer that question? I think we're good to adopt it, to move it forward rather today, but it wouldn't be able to be on consent if we just wanted them to respond.
Looking to the superintendent and...
Yeah, that's fine, because I do think we want to be able to answer any additional questions and make those clear, because I've got a couple of things that are running through my mind that I'm trying to get clarity on, but I would absolutely support that.
I've got a note. The note says that under General Statute 135-5A3, again, this is 134 and 5 are listed here in the legal references, an employee's retirement allowance shall be reduced for those employees who become retirement system members on or after January 1, 2015, if the member's retirement allowance exceeds the member's contribution-based benefit cap as calculated by TSERS.
So basically, what it said, that this can only, the reduction can only be made to the employee's benefits if they were hired after 2015. You can state as across the board, you don't cover that deficit, you're not legally responsible.
One additional thing I would like to clarify is January 1, 2015 date tied to an employee becoming a member of the teaser system, or when the actual organization, in this case the Wake County Board of Education, employs them? Those are two different things.
And so if I could add to that, this is part of what the clarity that I'm trying to get, because
Right.
my understanding is that if you were already a member of the teaser system and you are hired by a district, then you're responsible for any pension spike. But anybody that was not a member of the teaser system, you could make the choice not to pay that. And so, and I remember the conversation very vividly at the School Boards Association, but that is how I recall it, that if you hire someone from out of state and they pension spike, you're not responsible for it, but anybody within, you are.
So I think we have a good list of what we need to understand.
And I think it's just more information for the board that we can, have
Right.
at the meeting, because whatever the specifics are on the pension spiking rules, it is clear, the board never has to cover a reduction in benefits to the employee. That's what this is saying, because the statutes now provide that as an option for boards to do. I don't know of any that have said that they want to do that, so, this language should be fine, but we can chase down answers to the specifics.
The language does leave the board the option.
Yes,
unless expressly agreed to
exactly.
in the contract.
Absolutely.
So that could be stipulated as a term of hire in the contract, but otherwise you're not responsible.
No.
But I would like the time to have you all, take that deeper dive, possibly change the language or bring us some new language rather than try to hash it out today.
Yep.
So thank you, Chair Swanson and Superintendent Taylor, for that consideration. So can I get a motion to put 7910 on action on March 17th?
So moved.
Second.
All in favor, say aye. Aye. Any opposed? Thank you. All right, 6220, Child Nutrition Services.
This policy is one that came to you in December. We discussed it at our November Policy Committee meeting. In December, it was passed on first read, and in January, there was a discussion at the work session regarding alternative meals and the language that's in the policy. And at the January board meeting, it was pulled from the agenda for its second read. So the language that was considered then was statutory regarding no imposition of administrative penalties regarding meal charges, and then a clarification regarding September 30 of the following school year as to when any balance would be paid by the system any balance that CNS carries or has. It can't carry a balance forward. Ms. Lawrence is here in the room, so I want to make sure I'm using the right language. That will be taken care of by system funds, as CNS cannot carry forward a day. The discussion, as I understood it, was whether or not the board wanted to change policy regarding school system staff offering or not offering an alternative meal. The language in the policy says if a student is unable to pay for or charge a meal after they've hit the 3 days of meals, breakfast and lunch, a student will be served a designated alternate meal, which would be provided at no cost to the student. The discussion at the work session on the 20th was really about what is the alternative meal, whether or not board members supported an alternative meal, the cost of an alternative meal versus the cost of the full meal, and the resulting balance at the end of the year and what that means. So since it was pulled from January 21, I wanted to bring the policy to you today to ask if the board has a leaning or a suggestion toward this policy language, would give our staff the clarification they need moving toward the end of the year. You could also have this discussion, had another work session, but I didn't want this one to kind of fall below the fold, if you will.
So I will come around for questions, but I really feel like we need a full board discussion about this, because as we indicated, and I remember that discussion well, I think we all want children to just have the regular school meal, and we do understand there is a cost associated with that the board has got to figure out a way to pay. I don't think it's appropriate just to tell staff, we'll just figure it out and find the money. That's got to be part of our budget discussions. And I think if the board's values say, as a collective, that children, should just have the regular meal, we should reflect that in policy, rather than directing staff to just ignore the policy. That's the chair's opinion. So I'm going to come around to everybody. Mr. Hershey?
Do you want me to address what you were doing, or I have a different paragraph? Do you want me to wait on that?
No, just do, no.
Okay, so I have a different paragraph to look at, which is the next page, the child nutrition staff. And you go down and we say if a parent, that's the paragraph right there. And it's the sentence before the red. If a parent regularly fails, the principal can take steps, including, which I'm kind of, don't love that we have some of this language in there, notifying the Department of Social Services of suspected child negligence or neglect, and or taking legal steps to recover. So 2 things. 1, I don't like that language at all. I don't know if maybe we should provide a list of steps for principals to take, very specific. I assume principals have the authority to contact social services for any number of reasons if they suspect child neglect. But then also, why are we putting it all on school staff and principals? And my suggestion that I sent to Ms. Edmonds and Mr. Haggerty, and David Meader left, that's great, I was hoping he was going to be here for this, but a cost analysis of should there be a person or 2 in central services or CNS that is responsible for effectively a bill collector that reaches out. So it's not principals and front office staff constantly going back and forth, but we have like a central area, they get all the names.
So I'll yield to Tiffany to talk about the volume of what that looks like. And so if I think about 160,000 students and the number that may actually be there, I don't know if that's 3,000 kids, 5,000, or 50,000 now. It certainly becomes manageable at the school level.
Does it though? Because we're not,
Well,
my point is though that we clearly have an issue. And so what we're doing is not working. And we keep adding stuff to the plate of principals and administrative staff. And, you know, we had some administrative staff reductions last year. So I'm looking for ways to take stuff off the plate, no pun intended, of the administrative staff within a school. And if the issue is for CNS, then providing resources for CNS to take that over and go get it.
and Ms. Lawrence, if you don't have an answer to the question now, then you can certainly go back and get the data, but that, I think, would be the biggest issue,
Yeah.
is what is the number, and if you know, if it's high, would that
I wasn't
require-
expecting an answer, I just wanted to put that out there. It's more the language, though, in that sentence that I don't like at all, personally.
Dr. Ing?
I mean, would it be better if we just strike that sentence, I mean, that phrase,
Yeah.
where it says, which may include notifying, I mean, that seems more in the, you know, we're going down to the details in the policy,
Right.
which we don't really need to,
Right.
right? What's your opinion?
I mean, I'm against taking the language out, just because I think it's important in terms of the protection of children, that if you have, you know, a child who's not getting fed, who's being sent to school without a meal, who's not given money for a meal, or the parents have made no effort to contact the school to arrange for free meals, I think action needs to be taken. Now, I agree with Mr. Hershey's point that that seems to be an escalation of the action, and it might be better to give like a menu or kind of like a graduated response, but I wouldn't want to take it out. So I'd be in favor of changing it and modifying it, but I still think we have to, you know, we need to have some direction in there to take care of those kids.
I'll continue to go around, but I don't want to hash this out today, because I know Chair Swanson left, but I really think we need all aboard, as many as we can get here, present for this conversation. So in light of that, Ms. Gordon?
Yeah, I will keep my comment brief, but I would be in favor of the same as a graduated approach, but I definitely don't think that this, you know, contacting the Department of Social Services should be the end all to be all. So I'll just keep my comment there.
Yes.
So I'm not really disagreeing. I just think we should, like, we don't need to spell out the steps, but it can be a part of the steps. It could say, a parent who regularly fails, the principal shall determine the next course of action, period. And then that can be part of the list in there of, hey, if they're not doing that, but, because I suspect they can do that for other reasons as well, but there should be like, because we're saying stuff they can't do also. So we're starting to really get into making lists, which is, you know, I don't love.
My response and my feedback on that would be, you know, on one hand, I think that's right, and that's something that could be in, you know, like rules, like an R&P.
Right.
But on the other hand, I think it's also important to be able to, you know, give notice to someone that this is what the expectation is, and this is how serious it might be. So I can see it both ways, but I
I'd be
don't
good
feel
with
strongly
RFP
enough
on
to.
that, most likely.
Ms. Lawrence, thank
I
you.
did want to share that my team does call from central office, but in order to call everybody, I would have to put on the exact number of students. I do think it would be something like, you know, a full-time position, and this is something that's a part of somebody who already has like a full-time role in our department.
Yes.
So that's something like what I would want a business case study on. Does it make sense for us to hire? Because we're reaching a point where it might be worth paying that to bring the money in. And I think the other point too is, as far as the steps taken, I mean, I can imagine it's a lot to put on a principal to then take legal steps. So I don't know if that should be the principal's responsibility to take legal steps, or if that should be a position where they refer it to central services to take legal steps. So that's a lot for.
I mean, I think
I don't know if
it's
it's
going to be case specific, but normally if you got an issue at the school, as I think as the chairs recognize it, the principal recognizes that there's some neglect by the parent,
Yeah.
that's usually going to come at the school level with the principal calling, notifying.
Sure, I
social
get that.
services, whatever agency. So I wouldn't expect that to be a huge problem, but I think when those issues come up, that will start at the school level, and then they'll seek support from area superintendents in the district.
So can I ask staff and the superintendent to work with Chair Swanson and also Chair Haggerty with regard to the Finance Committee? Because I think it's appropriate to come back to a work session or at the Budget Finance Committee, because it is so direct. Our decision about what to put in this policy has a huge fiscal implication. And so for me, that's where I think it belongs, is either in work session or in Budget Committee.
So, Madam Chair, the board chair did say that I think he's talking about our next work session to have it added then, but I would assume if it's not that one, it would be the 17th meeting, I think.
Okay.
He wants to add it to the work session.
Okay, thank you.
And
Yes.
Chair Evans, if I can, I'm going to 100% support of that. I'd like to provide maybe some additional direction to staff.
Sure.
Which is the idea of coming up with an estimate seems like a reasonable ask, but I think we have a policy issue, which is who do you determine who gets the meal? If the only criteria for providing a free meal is a student, is it they can't pay? Is it they don't want to pay? Is it their refusal to pay? And there are very good reasons we've talked about for not wanting to embarrass a student or make them pay. But then if paying for the meal just becomes a choice, that anyone who requests it doesn't have to pay, who would pay?
Right.
And then are you kind of backdoor just funding universal meals, which I know a lot of us would like to do, but we also
Right.
know there's a big price tag.
Right.
But how do you come up with an estimate between, those students that are food insecure and are relying on that meal and someone that simply chooses or requests a free meal? I don't know.
Yep, yep. Mr. Nier, really
Yeah.
quick. Really quick.
Two quick things related to this. One, it would be my suggestion that this become part of the budget discussion, because I think it's a big enough potential impact. And I agree that needs to be discussed before the policy. And second, to Mr. Haggerty's point, just a reminder that during the pandemic, when all meals became free, participation rate shot up.
Thank you. Yeah, noted. Okay, can we move to 7610?
Yes. This is a new policy. This is that we're migrating policy from the old manual to the new manual. We want to acknowledge at the very beginning that in the old manual, this policy is mistitled. In the old manual, the title says Defense of Board Members, and when in truth, the policy is really about Defense of Board employees. So we want to acknowledge off the bat that the old policies are mistitled, and the new policy really does address Defense of Board employees. This will replace policies, plural, 3750 and 4700.
Ready?
Yep.
So 3750, the Defense of Board members, it's a policy from 1981. So it hasn't been updated or revised. So what you see in the black language, the black text, that is the School Board Association recommended language. And as you can see, we've adopted most of that. There are very few changes that we've recommended, just with, making the capital B for board. So for consistency, or for some language clarification, where we have like on number 3, corruption or malice on the employee's part instead of his or her, just some clarifying language there. You'll see that throughout. And the one thing that I did just want to say, because there is some confusion with this policy only comes into play when the district's insurance does not cover the defense of the employees. So it's fairly rare. And I don't have any data for you today, but it's not something that we have to utilize very frequently. It only comes into play when the insurance does not pay for the defense of an employee.
Mr. Ramey, do you have a sense of how often, like?
I can't think of when I've ever seen this happen in
Okay.
your districts. In theory, it could if an employee is sued for something outside the course and scope of their duties, if they were, if there's just an exclusion in the policy because the conduct's so egregious. And all the policy does in that case, it gives you the opportunity to decide whether you want to provide that defense. But yeah, I can't think of a specific example where that's ever happened in Wake. I don't know if anyone else can.
Vice Chair
No,
Hagerty.
and it's my understanding that the one case that someone could think of was outside of Wake County.
Yeah.
It's very, very rare.
Yeah.
For purposes of this policy, what's a board employee?
Looks like it's not defined. I would assume it's anyone who's been hired, by the board.
Isn't that just the superintendent? Isn't that only?
You
the
hire
superintendent?
all employees on the board report. I mean, you're getting.
I mean, we approve contracts, but
Yeah.
then we need
They're all
to
your
define
employees.
this because
They're all your
we
employees.
pass a budget, that employs everyone. So is every employer a board employee?
We could say
Yeah.
defense of school system employees if we wanted to. I mean, that's what it's
Same thing.
referencing, school system employees. So if we wanted to change the title, we could just say defense of school system employees. I mean, that would make it a little more clear.
If that's who we're talking about, I think there is a difference.
Yeah.
It is.
I do.
Statute does say board.
Yeah.
To me, it's the same thing. I mean, the
Right.
board is the entity that employs everybody in the school system on the recommendation of the superintendent. So I don't think it's,
Yes.
Yeah.
sure.
It's just not our normal.
Yeah, you don't think,
Right.
you're just, right, so because you're used to thinking that you manage and supervise only one employee, and that doesn't feel like, a school custodian works for the board directly, so you could just say defensive employees. That would be the easiest.
And honestly, from the old title where it says defensive board members, from the 80s, I seem to recall membership being employees of the board way back when. It seems like that was a referenced term, so I think that they used it in the 80s to reference the employees of the board, but it was just a different time.
Dr. Ng, did you have something?
Yeah, I mean, it just brought back that earlier discussion about whether the board members are employees.
Board members are not employees, but everyone else is.
We don't have it says.
we say no.
Yeah, this policy doesn't address board members.
So maybe it should be defensive non-board employees.
I think if you all think that the board in the title there causes some confusion, it would be very, as Dr. Matilis said, just say defensive employees. That's perfectly clear. I don't think you need that word board there.
Okay. Any other questions? All right. Can I get a motion to put 7610 on consent on March 17th?
So moved.
Second?
All in favor, please say aye. Aye. Any?
Clarification, would that include with the change in the title that Dr.
Yes.
Matilis recommended? I assume you all agree with that.
Yes. Are there any opposed? Great. Okay. Capturing video on campus. 1310, 4002. So Dr. Crane, I don't want to steal your thunder, and you clearly don't have 30 minutes, but we know that there's new law went into effect January 1, and we had been working on this prior to that date, but anyway, please.
I don't know that I have any thunder to steal, honestly. The topic came up at the June Policy Committee meeting in 2025 last year, before the start of this school year. The request to talk about sort of what is allowed or not allowed in our cell phone policy, when students are allowed to use their phones, et cetera, and how that's squared with Policy 1310, parental involvement. This policy 1310 now includes language, as you probably remember, from the Parents' Bill of Rights that speaks about I get there. These are now parental permission required. The creation by school system employees of a video or voice recording of the student, except a recording made for use solely for any of the following reasons: a safety demonstration, including one related to security and discipline on educational property; 2, an academic or extracurricular activity; 3, classroom instruction; 4, photo identification cards; or 5, security or surveillance of the building, grounds, or school transportation. My notes from that meeting say we've got this language about prohibiting us from capturing certain kinds of video or voice recording. That doesn't say pictures, right? And then we have our cell phone policy, which really speaks to students not being able to have their phones out during class, that they don't have to have permission to use in case of emergency. Do you remember any interest in discussing this topic? I didn't want it to, again, fall below the...
No. So I know that Ms. Rice had a concern about, oftentimes, and this can be in a sense of deliberation if something rises to the level of an appeal, that we consider video evidence often. We consider including student cell phone data or video or photos, and oftentimes, whether it's an adult or a student, it's not believed unless they see it. And so that was a concern that she raised. And then I think the state law, sort of, it went further than our policy did initially, where phones have to be turned off and put away. So I think that was just sort of some questions about, when there is an incident at school and students get their phones out and they start recording, are they in violation of policy at that point? I think it was one of the questions. And then I remember, Chair Haggerty, you had, I feel like several concerns, and I'll let you take the floor.
I appreciate that. There's a lot of issues as we try to resolve all of these policies. One of the things, to the point that Ms. Edmonds had described, is that you do hear people that bring up questions regarding the use of phones, either for personal safety or to record some sort of incident. If you talk about the relying on videos when there's a violent incident or an episode. And, I can give you a story of when this policy came up. I had some parents that had asked me to question it because their personal experience, they had students that were being verbally abused by an athletics coach, and they took it to the principal, and the principal did not believe them. And repeated efforts, there was no action until they finally captured it on video. And so from the parents' point of view, access to that video was really important, to resolve the issue. And so I was trying to think if there was any language that could create some sort of whistleblower protection or exemption from discipline from a student that might have turned on their phone, might have used the phone in a time and a way that was not permitted, but for that explicit purpose, right? But what I found was it opened itself up to what looked like a lot of loopholes as well. If capturing an incident of violence is an acceptable use for turning on and capturing your phone, does that get us right back to the situation we talked about before, where there's a fight, there's a ring of students, they're all on their phone, first responders, SROs, or staff can't get to it because of all the students recording it. So I see a potential problem, but I also don't have a solution. The solution that I'd considered, I don't know, holds up if you really scrutinize it. So that was some of the discussion. And then I think there were also some issues regarding the last policy that we showed that had the exemptions for when students could be recorded. I think the exemptions take care of some of the issues that had been raised about we don't want to involuntarily restrict staff from, security video and other things that promote student safety. So I think that Section 11 addresses some of the questions that had come up in our previous discussion. And then as long as we have this whole cell phone policy up, I'm a little concerned about just conflicting guidance, not guidance, but information we've gotten kind of around the table about like the use of personal laptops and bringing in personal alternatives to Chromebooks. We've talked about situations where families have needed like an app that might only be on a Mac, and can they bring in their own device? And the thought being, well, that's perfectly reasonable if they have an accommodation, or even if they don't have an accommodation, we can't tell them not to use their own laptop. But then you go back to this policy that seems to be intended for phone use, but it includes laptops in the definition. So I've heard that the students could bring in personal devices in terms of laptops or Chromebooks, as alternatives to their school-issued Chromebook. But the definition here, again, not to the school-issued, but to personal devices, it would seem to be captured in this definition of personal device. Tablet computers, laptop computers are all covered in that personal device. So that sounds like that policy and maybe the state law behind it would prohibit the personal laptop from coming in. And so I just wanted to ask interpretation of the policy.
I think I could take a step on the last question. I mean, the last point about bringing in a personal device, I think the statute only applies, looking at the statute, not the policy right now, but it only applies, or it provides an exemption for any wireless communication policy that's if the use is authorized by a teacher for educational purposes.
Okay.
I think that would probably cover you. If you're using it during class to do your schoolwork, that's fine.
And that's in the statute.
That's in the statute, and it's probably in the policy as well.
Well, you highlighted it, I believe. Or personal laptop computers that are used exclusively for
There we go.
group
There we go.
instruction.
So we did address that.
Okay, all right,
Yeah.
thank you.
We addressed it as personal laptop computers.
Yeah.
We did not extend that to tablets or other devices of a nature other than a laptop. And the pointing to 3225 technology responsible use, that policy allows a principal to make a school decision about using personal laptop devices or personal computing devices. So our policy says consistent with 3225, and 3225 says each principal is authorized to make a call for their school as to whether or not they allow that. One of the reasons we added this clarification language is because last summer I got several calls from principals saying, does this mean I can't continue to allow students to bring their personal laptops? Do I have to tell them no? Oh, no, we never intended for it to be that. But you, again, might see some differentiation across campuses based on what a principal believes is best instructional practice or community practice for their campus.
I don't know what any of the other discussion questions were, but those are the ones that I remember.
Yeah, and that covers everything. I think, the episodes of violence or, school fights, just to speak plainly, is complex. Because again, at the school level, and then if it rises to a board level appeal, we all look at that evidence, and some of that evidence comes from student phones. And it makes me wonder, with the way the law is written, not just our policy, but the law is written, are students violating state law if they record a fight at school or an incident at school. The same thing with, the example you gave, the bullying, or, so it doesn't have to be a fight, but the bullying, or, and I don't have an answer either, but I think those are questions that we're, grappling with and looking for staff to help. So I didn't see this as a policy that we were looking to revise necessarily, but that was what I recall that was sort of still hanging out there from the discussion last time we had it.
So, Madam Chair, if I could, and I understand the complexity, and so what we can do is just think about suggestions to the policy of language that might be added to address what we know is the fight culture versus a student documenting for some other purpose. And so, and that is one of the professional judgments that administrators get to make, that they have a professional ability to say a student was being bullied in the bathroom and somebody recorded that, versus a fight in the lobby and hundreds of students run up. Professionally, a principal has the license to make that judgment call. So we can think about what the language might look like, but I know what we're talking about is avoiding the fight culture, but not taking away a kid's ability to document properly.
Right, yes, thank you for bringing that up, because the fight culture is a problem, for sure. Well, staff, and I can't believe it, we actually did it. It is 2:59, and I'm going to adjourn us. And thank you all for, being cooperative and getting us through this full agenda today. Thank you.
Yes, I